I will be talking about case management statements. Case management statements can be found in Chapter 17 of our textbook, and in order to understand what case management statements are, it is important to understand where case management statements are needed and applicable. So where are case management statements needed? The case management statement, also known as Form CM-110, is needed during the case management conferences. These conferences are one of the first meetings that is held by the trial court for many reasons. As an overview, case management conferences are usually meetings held before the trial between the attorneys and the judge. Depending on the court practices, action, and judge, there can be many or very few conferences held before the actual trial. Ultimately, this conference governs the course of the action up through the trial and aims to identify the issues in the dispute and the evidence that will be presented. The CM-110, or the case management statement, is a crucial form needed for this step in the litigation process. Now that we know where a case management statement is needed, we now have to figure out what is a case management statement, what is in a case management statement, and most of all, how do I complete a case management statement? Well, the case management statement is a 5-page mandatory memorandum that generally includes the following: uncontested facts, contested issues of fact and law, exhibit lists, witness lists, and jury instructions. These elements of the case management statement seem broad, but as you go through the 5-page memorandum, you'll find that there are specific aspects of the form, such as the complaint, the cross-complaint, and a brief statement of the case, and all the damages. You will also see other aspects that describe how the trial itself is, such as the trial date, whether the trial has a jury or not, and even the estimated length of the trial. It is important as an attorney or paralegal to properly prepare this form, as it is mandatory and can give the judge an impression of how the trial will go. Every case is assigned to a case management department. With this department, they involve scheduling. If a court decides that they would like to hold a case management conference, they will notify you of a date, time, and department to which the conference will take place. As with any form, it is important to reference the rules of court in order to understand how and when forms should be submitted for filing. According to California Rules of Court, Rule 3.75 states that it is important that the CM-110 be filed with the court no later than 15 calendar days before the initial case management conference. This includes the action of each party serving it on all other parties in the case. In addition to timing of state, it's also important to understand that you can have a joint statement, which means that in lieu of each party's filing, any 2 or more parties may file a joint statement. And finally, it is important to understand the contents of the statement. Parties are required to use the case management statement and fill in all applicable items on the form to be valid. Now that you have a brief overview of the case management conference and statement, it's time to practice filling out the form by using the Sampson hypothetical we've been using all semester. To refresh your memory, I provided the hypothetical on the next slide. I recommend that you go to courts.ca.gov/forms.htm and pull up the CM-110 form to follow along with me. You'll be able to see just how extensive this form is as we take on our hypothetical and fill out the form together. We will be filling out the CM-110 using the Sampson v. Emerald's Catering hypothetical. I recommend that you take a moment to pause the video and read over the hypothetical to refresh your memory. On the first page, you will notice a few things. To begin, we will fill out the top general information portion as usual with Ina Sefrin and the firm's information, along with who your firm is representing. In this case, it would be Benjamin and Sarah Sampson. You will then fill out the Superior Court information and specify which branch. To be consistent, the Sampson v. Emerald's Catering case has been classified as a limited case because the Sampsons required $25,000 in remedy as a result of the events that took place at their fundraiser. This is where the new information comes in. On the first page, it'll have a box where a case management conference is scheduled. Now, Sometimes you will fill out the case management statement without having a scheduled case management conference. In our case, I've created a notification in which the courts found that we will have our case management conference on November 12, 2020 at 8:30 a.m. in Department 5. We don't yet have the division or room number. Sometimes the case management conference will be scheduled in a different court. In that case, you will put the address of the court in the box below the date, and sometimes you can even appear at your conference by telephone. In that case, you would check that box and state the names of the people attending the call. Once that information is filled in, you will then notice that there are numbers 1, 2, 3, and 4 on the first page of the statement. Number 1 is the party or parties. You will only select A or B. In our case, we will check box A, which means that we are submitting the statement for Benjamin and Sarah Sampson. If we are submitting a joint statement, we would check box B and state the names of the parties. Next comes section 2, the complaint and cross-complaint. This is to be answered by plaintiffs or cross-complainants only. In context, we will put September 9, 2020 as a date that the complaint was filed, and leave box B blank. Moving on to number 3 is service. We would most definitely check box A. In our previous assignments, we made sure to serve the opposing party or counsel with the documents that we filled out. So in this case, we can definitely confirm that all parties named in the complaint and cross-complaint have been served, have appeared, or have been dismissed. If this were not the case, you would then look at boxes B and C of 3. Finally, we have section 4A, description of the case. Section 4 bleeds onto page 2 of the statement, but we will first check the box applicable. In our case, the first box is applicable because this is a complaint, and then we would state the cause of action. The Sampson cause of action was a breach of contract. Moving on to page 2, you'll see that we have sections 4B, 5 through 9, and 10A and B on this page. Let's start with 4B. This section is essentially where you provide a brief statement of the case, and you include any damages that may have resulted. In context, I stated that the Sampsons and Emerald's Catering entered a contract where Emerald's Catering was to supply entertainment, food, and decorations for the fundraiser that the Sampsons planned. Emerald's Catering showed up exceptionally late and did not provide the services they promised in contract. As a result, the Sampsons are looking to receive $25,000 in remedy for the damages done to their reputation and for loss of potential donations as a result of Emerald's inaction. I put this because it is a brief statement of the case, and I also made sure to include the damages and how much in damages they were looking for. Next is section 5 and 6. Section 5 is whether or not you would prefer a jury or non-jury trial. In our case, I suggested a non-jury trial. Section 6 is the trial date. Here you would state when the trial is set for, but in our case, we would check box B because we have not yet been given a trial date. If you chose C, you would indicate the days or dates the parties or attorneys are not available. In our case, just for fun, I stated that the parties and attorneys would not be available December 25th, 2020 because it's Christmas. Next, we have section 7, which is the estimated length of trial. Here you would indicate how long you believe the trial would take. In our case, I put box B in hours and stated that it would take 72 hours to reach an agreement. We then have number 8. This section is about trial representation. You would check the box applicable and then fill in the information below. In our case, I stated that our party is being represented by an attorney, and then I put the information below. I find that section 8 is actually very similar to the general information box on the first page. We state the attorney's name, the firm, their address, and their telephone and fax information. We then move on to section 9, which is preference. This box is about code preference. So if you feel like your case is entitled to a specific code section, this is where you will put that. We did not check the box because we do not feel as though there is a specific code section that we prefer. And finally, we have section 10A. This is about alternative dispute resolution, also known as ADR. This section is essentially discussing the alternatives to settling a dispute. There is mediation, arbitration, and other methods that are provided under Code of Civil Procedure Section 1141.11. You'll see a larger list on 10C on the next page. On page 3, you'll see Section 10C. This section indicates the ADR process or processes that the party or parties are willing to participate in, have agreed to participate in, or have already participated in. In this section, you should check all the boxes that apply. In context, my client did not prefer to receive mediation or to settle in conference, so naturally, page 3 is left blank. Although, many disputes that are considered smaller would most likely end up being settled through mediation or conference. I think that in many regards, this is a cost-efficient route to take because the litigation process can be an expensive one. Here, I've listed pages 4 and 5 of the case management statement. You'll find that there are so many categories that may be applicable to the cases that you'll encounter. As you can see, the case management statement is essentially a form that is meant to outline the specificities of the case, in order for the judge to get an idea of what the dispute is about and how it may go during trial. Because our hypothetical is a bit vague, I checked the boxes that would apply. For example, on page 4, section 16, I checked the box A, which states that the parties or party have completed all discovery. As you all know, we previously completed form interrogatories, and let's assume that we received a response back. This is why I checked the box. Finally, I checked sections 17 and 19 on page 5. Section 17 talks about economic litigation. I checked box A, which states that this is a limited civil case, i.e. the amount demanded is $25,000 or less, and the economic litigation procedures in Code of Civil Procedure sections 90 through 98 will apply to this case. Then there's section 19. I checked box A, which stated that the party or parties have met and conferred with all parties on all subjects required by Rule 3.724 of the California Rules of Court. For the sake of this assignment, I have checked this box. Finally, you would go to section 20, make sure there are no other additional attachments, and then you will make sure that this document is dated and signed by the attorney. This concludes my presentation on case management statements. I hope that the background that I gave you will help you in your paralegal careers and that you know that the case management statement is a form that's required to be filed 15 days before a case management conference scheduled by the court. You'll find with the statement in the conference that this is a means for the court to understand what the dispute is about and give an idea of how the case or trial will proceed. Many litigants would aim to end their dispute during these pretrial conferences in order to prevent spending their hard-earned money during the extensive litigation process. Thank you for listening to my presentation, and I wish you the best with your future case management endeavors. Bye.